Today was day 2 in Dr. Marie Russell's Daubert hearing in the Karen Reed case. Now, there was already one full day of this Daubert hearing, which we're going to break down very, very quickly for you. And then we'll move on to what happened today in day 2. So day 1 essentially was where there was a lot of questions by the defense attorneys. So this was the new attorney, Robert Alassi. He was the one directing Dr. Marie Russell, going through all of her experience and going through all the articles that she wrote and was peer reviewed, and all the other articles and studies that she relied on in coming to her conclusions. And they put up the picture of John O'Keefe's arm, and she went through the different patterns which she noticed, why she believes within a reasonable degree of medical certainty that this is actually a dog attack. So that was pretty much 6 hours in less than a minute. But then there was the cross-examination began. And this really was the tail end of day 1. And then it continued today in day 2. So Hank Brennan, where he started, and by the way, in case you were wondering, Hank Brennan, as we saw today, is a fierce, fierce advocate. He's going to be very strong, and he is a very strong adversary. So this is going to be very interesting, definitely the second trial. So Hank Brennan started off by saying everything that Dr. Marie Russell is not. And this is a common theme with cross-examination. When it's your witness, it's your expert, you want to stress about what type of expert this witness is. So you talk about all of the emergency medicine and forensic pathology and everything that she is an expert in. When you're on the other side, when in this case Hank Brennan, you got to point out everything that she's not. So for example, you have an ER physician, you say that she's not an accident reconstructionist and she's not a biomechanical engineer. And if you have an accident reconstructionist on the stand and this is not your witness, then you point out that that person never went to medical school. So this is just the way the game is played. Okay, so he's trying to point out everything that she's not. So the first thing that he says is that she's not a specialist in orthopedics, right? She's not an orthopedic specialist. When you're an emergency medicine physician, you're not an orthopedic doctor, right? I mean, everybody understands that the same way orthopedic doctors are not, pain doctors. And, there's all different types of specialties. Are not cardiologists, and each different specialty specializes in their specific area, right? So this is just something that he was bringing out. Now he got some pushback on this, where Dr. Marie Russell said that, well, she kind of made up the specialty that she's a specialist in emergency orthopedics. Now there's no real specialty emergency orthopedics, not that I'm aware of. So I think what she was trying to say is that as an emergency physician, of course, you have to be well-versed in many areas of medicine because you're having people coming to the ER with all different types of issues. So yeah, you have to know a little bit about everything. That's just the nature of the position. That doesn't mean you're a specialist. You're not doing surgery, but you still have to know your way around all the different treatments and different diagnoses of all types of conditions of the body. So you're kind of like the quarterback. You got to figure out everything that's going on with the person. So I think what she's trying to say is that I'm familiar with broken bones. People come to the ER all the time with broken bones. You don't have to be a specialist to do surgery in order to diagnose and treat a broken bone, at least until that person goes to an orthopedic doctor. So I think that's what she was trying to say, but she kind of made up this specialty of emergency orthopedics, and that's why she was fighting back against Hank Brennan, which I think would have been a little bit easier or better for her to just say, yeah, you're right. I'm not an orthopedic specialist. Okay. Just concede on that issue. But there was still some back and forth about that. Okay. Now also he brought out the fact that she's not a self-defense expert. Okay. And we spoke about this in the last video when we analyzed the first Daubert hearing, that he's kind of making up this new specialty of self-defense specialist. I mean, you ever heard of a self-defense specialist? Like, who's he talking about? Someone in karate, someone in martial arts? Is he talking about someone in the army? Self-defense? Like, what is a self-defense expert? People teach self-defense, but does that mean that they're a self-defense expert? What do you have to do in order to become a self-defense expert? So, but still, he's trying to create categories to kind of show that, let's look at all the things that you're not, right? So he said you're not a self-defense expert. Then he spoke about, everybody remembers he handed her this book that has to do with dog bites. And she opened the book and she looked and she's like, oh, these people aren't even licensed. They're not professionals. So, I mean, maybe they're somewhat of professionals, but they don't have degrees specifically, I guess, in medicine or anything that she would recognize as reliable source of information. Okay, so that was a point that happened in the first day as well. And then we had the argument where Hank Brennan was pointing out that she kind of flip-flopped with her testimony. And also she said possibly a dog. And this was obviously a big problem that she shouldn't have said. especially if you're trying to be on the side of Karen Reed and say that this is a dog attack. You shouldn't say it's possibly a dog attack. And then she said, well, I was really explaining, this is in the first day, I was really explaining that, as a doctor, you never say something 100% certainty. So I was just saying it's possibly a dog attack, but really it's a dog attack. Okay. And definitely I can still say that with a reasonable degree of medical certainty. Okay. So that's kind of where he left off day one. And now we're going to pick it up on day two. And I want to show you something. I want to show you a clip, which I think was just improper. And I was mentioning this on the live stream today while we were live streaming it. And I was just really surprised that Judge Cannoni was allowing this type of questioning. And I'm going to show you the clip in just 1 minute. But before we get into it, I just want to pick up a little bit before what happened before we get to this clip. And that was, so he picked up, Dan Brennan picked up on this specific line of questioning about how she flip-flopped with her testimony. At one point she was saying that it's possibly a dog, or possibly likely a dog, and pointing out in the different transcripts when she kind of flip-flopped her position. And that was a decent point that he brought out. Then again, he went through the fact that she's not an accident reconstructionist. And then we get to this clip. Okay, so I'm going to play for you this clip. And I was just really surprised that, and there was even objections that were made to this line of questioning. I'm going to explain a little bit more as I play it, but let me just play it for you first, and then I'm going to tell you what the problem is. All right, so here we go. And I just speed it up a little bit for you so we don't have to sit here for a longer time than we have to.
When you excluded the car accident, did you know anything about this collision between the Lexus and Mr. O'Keefe? Did you know anything about it?
Objection, Your Honor.
Okay, now, you hear the question? He said, he's asking, okay, when you came to your conclusion, did you know anything about the collision between the Lexus and John O'Keefe? Okay, what is that assuming? What type of question is that assuming, and what type of foundation do you not have right now? That there was actually a car accident. Okay, so this is a classical problem where you object because there's been no foundation yet, definitely with this witness, that there was a car accident at all. So you can't just assume that there was a car accident and then ask a question to the witness based on this assumption that there was a car accident, then asking the person questions about that car accident, because it just lacks foundation. So it's assuming things that are not in evidence. It lacks foundation. So therefore, they made the defense right away made an objection. Now let's see what happens.
Can you answer that question, Dr. Russell?
So the judge did not respond to the objection, and essentially what she's doing is overruling the objection by saying, "Can you answer that question?" What do you mean? Can I answer that question? How can I answer that question if it's you're asking me a question of fictionally, again, fictionally, if there was an accident here, did I know about the accident? I mean, of course you can't answer that question, but that question should never be allowed to be answered because it lacks foundation. So I was just sitting there with my mouth open when this happened. I was like, wait, you mean this question is actually going to be given to the witness to answer? So let's continue and see what happens.
Did I know anything
Yeah.
about?
Did you know anything about how it happened?
I was somehow I knew that. Well, I believe I knew that the car was backing up. That's what I was. Somehow I got that information.
So
The
when
car
you were
backed up.
excluding the collision and this differential diagnosis, did you know how fast that Lexus was going back when it struck Mr. O'Keefe?
No.
Did you hear that question? Do you know how fast the car was going when it struck John O'Keefe, Officer O'Keefe? How is that question allowed? I couldn't believe that this question being allowed. There was an objection made. It's very clear that this is improper. And you're asking a witness, basically, did you know that this actually happened when it didn't? There's been no foundation that it actually happened. Yes, it's an argument that the Commonwealth wants to make, but when you're dealing with this witness on a Daubert hearing, you have to lay the foundation. And that's what the objection was about. And the questions are still going to go on like this.
Do you know how far it traveled when it hit Mr. O'Keefe?
Objection, Your Honor.
So it's a question. The question's proper. Let's see if she can answer it. She may not be able to answer it as asked.
So again, do you know how much of a distance the car traveled before it hit John O'Keefe? And there was an objection. And the judge says, no, that's a proper question. How is that a proper question? The same problem that we had the past few questions. It's not a proper question. So again, I was just saying that I'm just surprised that this question was allowed to be asked. And this witness now has to answer this question as though there was an actual accident without any foundation being laid. And as though it did actually, in truth, travel a certain amount of distance. So it's just surprising.
Do you know how far the Lexus traveled backwards when it hit Mr. O'Keefe?
Your Honor, I'm objecting to the
I
the assumption.
understand. I understand, counsel. Can you answer that question as asked, Dr. Russell?
As asked, no, I don't know.
When you excluded this collision as differential diagnosis, did you know the angle of the collision between the car and Mr. O'Keefe?
I'm going to see counsel in a second.
So again, the same type of question. Did you know the angle in which it hit John O'Keefe? Again, you're assuming that there was an actual interaction between John O'Keefe and the vehicle. So I understand the Commonwealth wants to make this argument. And again, you can argue this to the jury. You're asking an expert witness to opine about facts that are not in evidence yet and facts that you did not lay a foundation for. So I don't understand how this goes on. Now, eventually, she does, after this sidebar, which we're going to skip over, she does eventually say, okay, you have to change it to alleged, which should have happened a long time ago. But she still allowed some of those questions to get in, which I just very surprised. So just watch what happens here, because immediately after this sidebar, he asks again the same type of question without saying alleged, and it goes on. And then eventually he's required to say alleged. But let's just see. I'm going to fast forward to when they're done with the sidebar.
When you engage,
Can I listen to this question now?
may I?
Yes.
When you engaged in differential diagnosis, excluding a car collision as the cause of these abrasions, did you know or learn any information about the angle of the strike between the Lexus and Mr. O'Keefe?
You hear that question? Again, that's an improper question. And then eventually after this, he's going to correct it. So, okay, that was like just one of the parts where I was just a little surprised that actually those questions were being asked. I thought they were completely and totally improper. It's not really going to make such a big difference because you don't have a jury there. You know, like if this was in front of a jury, I would be absolutely, if I was a defense attorney, I'd be absolutely going haywire about this. Absolutely. But this is in front of the judge. So the judge, you know, you're not impressing the judge so much, you know, like it's just the judge making this determination. So ultimately, as much as I believe that question was improper, but the judge is the one that's going to make the decision here. So it's not as terrible. Like you're not going to pull a fast one on the judge because some slick lawyering, you know, generally speaking, that's not what happens. So, you know, it's not as, you know, as much as I think it was improper, I don't think it's gonna make such a big difference. Okay. So let's just move on with all the points that Hank Brennan made. So he asked them a lot of these questions about the sneaker, about the debris, about, you know, did you take that into consideration? Did you take the other thing into consideration? All these, did you take the fact that, you know, Karen Reed told somebody, Officer Saraf, I hit him, or that she said, it's my fault. This is all my fault. Did you take that into consideration when coming to your conclusions? Now, again, these are, I'm not 100% sure what this has to actually do with the Daubert hearing. That's why I was like a little confused. That's why I was tweeting out on Twitter. This is not really, this is going beyond what generally happens in a Daubert hearing. You're just asking about the methodology. So this is an emergency physician, and you want to know what's her methodology when coming to a medical diagnosis. So whether you know that she said to Officer Saraf at the scene, I hit him, what does that have to do with actual medicine? Does that have anything to do with medicine? Does that have to do with methodology of coming to a diagnosis or treatment? So like this was really getting off the rails a lot, and Judge Cannoni kind of let it get off the rails because I don't think she wants to shut either side down. So she's kind of letting everything go, which is like, this was like a mini trial. This is like a lot of like closing argument type of stuff was going on in this hearing. And I was like, this is getting way off the tracks of a Daubert hearing, which is why I tweeted that out. But anyway, let's just continue with what he said. Okay. She never visited the scene. Like you never visited the scene, like as if that would have something to do with an emergency physician's methodology. You think any emergency physician in the world, you come into the ER and this guy says, you know, I was just hitting the car in the intersection down the street. Oh, really? Let me go run down there and check and take some measurements. I like, seriously? You know, like of course that doesn't happen. So, but again, you know, he's trying to bring out some points. And what's interesting here is that you're not in front of a jury. Like I understand, like if you're in front of a jury and you're trying to win your case, so you kind of bring out these points, you know, to try to discredit their witnesses, and then you can come back to that during closing argument. But this is a Daubert hearing, you know, so like you're kind of supposed to leave it within the parameters of what a Daubert hearing is. You're not like supposed to go way off the track and try to argue your entire case. Okay, but that's something that we saw here. All right, so she never visited the scene. What about knowing about whether there was some microscopic pieces of tail light in the sweater or sweatshirt? Didn't see that she didn't see the investigative report. And then he actually went through the different wounds. Now, remember, the testimony here was that the pattern of these wounds is what is convincing Dr. Russell that this was a dog attack. So now what he does, again, this is good lawyering. And I kept saying throughout the live stream, if you're able to join me, that this is good lawyering. He is doing the best that he can. And he's doing a good job, because this is what lawyers are supposed to do. You're supposed to try to find weaknesses and, poke holes in this expert. And this is one of the ways to do it. Like when you have a lot of things together, like when you have circumstantial evidence all together. So let's say you have a case, you're the defense attorney, you're defending a case, and the prosecution's whole case is circumstantial, which means that they need every single piece of evidence to kind of tie everything together. So what you'll do as a defense attorney is you'll take each individual piece and you'll put that up in front of the jury and say, what does that show? That shows nothing. And if you look at each individual piece, that shows nothing. So that's kind of what he's doing here. He's taking a page out of the book of a defense attorney when they're dealt with this type of circumstantial evidence. So they kind of take a page on it and say, well, if you look at each individual wound, and if you just look at this in a vacuum, can you absolutely tell me that this is a dog attack? No. So that's what kind of he went through. He went through, okay, let's call this wound 1, wound 2, wound 3, wound 4, and let's just, separate it. And she said, yeah, I mean, separately, I could see why it would be a dog wound, a dog bite, but I'm not going to absolutely, rule out any other possibility if I just look at that specific wound. So he spent a lot of time doing that and going through each individual puncture and punctate laceration and different terminology that she used, and trying to argue that, this is each individual wound you can't even tell me is from a dog. And then he also got into some differences of her opinion when she's saying whether it's from a teeth, whether it's from a bite, or whether it's from a scratch, from a claw. There seems to be there's some differences in exactly what she testified to, and how he kept trying to say how your testimony is evolving. This is also common. What we do as lawyers, we try to show that this witness is not being forthcoming, and their testimony is evolving. So that was also something that he was trying to show. So he was really going into the wounds. If you look at the different wounds and the pattern of the wounds, and what would this be? Trying to show that, there's one very light wound. If you look at that first wound all the way on the top of the arm, so there's 2 big scratches or big lacerations. Then in between them, there's a very light one. So he's saying, how can this happen if it was a dog bite? Well, how would there be 2 very deep ones and then one laceration in between those 2 that's not deep? How is that even possible for a dog to do that? And she said it's still possible. Skin is very elastic. It can move around. And especially if you're fighting with the dog, it's definitely possible for that to happen. But he's still trying to make that point. Okay, so then he tried to say that, wouldn't you agree with me? And he's very skilled. And he almost got her to actually agree with this, because skilled attorneys can actually get sometimes these witnesses to agree with them if they say it in the right way, in the right intonation. Sometimes you do that, especially sometimes when you're very, very difficult with a witness. Sometimes you're like fighting with the witness, and then you kind of calm down. This is just like a strategy for all you. This is what you'll find sometimes when these good lawyers, they'll be very strong with a witness, and then all of a sudden they'll say, okay, I mean, wouldn't you just agree with me on this thing? And then the person feels like sometimes a witness will fall for it and say, yeah, I guess I can agree with you on that. And then you've got them. So this all strategy. So this is what he tries to do. He's very combative with her. And then all of a sudden, he kind of, becomes like this soft spoken. Well, wouldn't you agree with me that this is just a soft science? This dog bite business wouldn't you agree that this is not like a real science? And a lot of times you'll get the witness to do that, but he actually didn't get her to agree to that. But it was a close try. It was a good try. Okay, then he brought out the fact that there's the federal medical examiner who had an opinion that said it's not a dog bite, and Dr. Kenneth Kinsey and Dr. John Walsh. So he spoke about that her opinions are in conflict with their opinions. Okay. Then he also asked her some little bit more interesting questions. Again, maybe this would work on a jury more than a judge, but said, did you do peer review on your specific opinion in this case? Okay, did you share your opinion? And this never happens, by the way. You never have an expert who you hire for a case. You give them to review the medical records and the pictures or whatever, and then you say, what's your opinion? They don't send that opinion to some other doctor and say, do you agree with my opinion? It never happens. But nevertheless, this is something that Hank Brennan wants us to do. And he's saying, well, your own opinion in this case did you peer review? And of course she said no, like nobody does that, but she said no. Okay. Then he asked a question about, the dog, Chloe, was available for you. And in fact, we even took molds of her teeth. And did you ever ask for that? Maybe that would have been able to help you determine whether this was actually a dog bite from Chloe or not. Now, as soon as he went down this road, I was thinking to myself, the whole argument here about forensic odontology not being a reliable science, remember that whole line of cross-examination? Well, that's true when it comes to specifically matching a specific dog to a specific wound. So this is exactly the prosecution's argument. The prosecution's argument is that forensic odontology is not a reliable science, but actually she agreed with that. Dr. Russell really agreed with that, but only as it relates to drawing a connection between a specific dog and a specific bite. So that's exactly what he's suggesting that she does. So how can you have it both ways? How can you say, on the one hand, you should have gotten the molds of Chloe's teeth and then match them up to the wound, but you yourself, Hank Brennan, said that it's forensic odontology, and definitely Adam Wiley said this, is not a reliable science, which Dr. Russell even agreed when it comes to matching a specific dog to a specific wound. So that's what I was just thinking myself. Okay. So then that was essentially it. And then we heard on redirect. So we had redirect from Robert Alessi. So Robert Alessi, again, just brought out some of the points that we kind of already made. That first of all, is there any ER physician that is also an accident reconstructionist? Have you ever heard of such a thing? And of course, the doctor said no. Like, ER physicians are not accident reconstructionists. They're not, and generally speaking, ER physicians are not board certified in orthopedics. They're not an expert in orthopedics. Every ER physician is like that. And still, you routinely evaluate injuries as resulting from a motor vehicle accident. That is what an ER physician does. So of course, that's what an ER physician is able to do. Of course, it's within your expertise to say that this injury is from a car accident. Okay. Then also you talked about biomechanics. Okay, that you don't have to be a biomechanical engineer to be an ER physician. And nobody's ever heard of somebody who gets injured and they go to an accident reconstructionist, right? Nobody does that. And then also he pointed out that this idea of self-defense that Brennan brought out, that you're not a self-defense expert. He said, did you ever say anything about being a self-defense expert? Or did you say that these were consistent with defensive wounds? Meaning they're different things. Whether you're a self-defense expert is different than being able to say that these appear to be defensive wounds, right? You don't have to be an expert in self-defense. So he just stressed that point. Okay. And then he also said this point, that he was trying to make a point that you didn't observe the car. You didn't go to the scene and look at the taillight and look at the car. And this is kind of like, similar to the argument I keep hearing about the ARCA experts that didn't actually see the car. And so he was trying to use this against Dr. Me Russell. Did you actually see the car and see the taillight? So Robert Alessi just said, okay, is that even necessary for an ER physician to see the car? Does that ever happen? Does any ER physician, when someone's involved in a motor vehicle accident, say, you know what, before I can actually determine this is from a motor vehicle accident, I have to actually see the car? You ever heard of that? Of course not. It doesn't happen. So it doesn't do anything to take away from her expertise. Okay, and then he goes into this idea of how do you determine dog bite wounds? Because one of Brennan's main points on his cross-examination was to say that really there's no methodology. He kept saying this. There's no methodology. You're not using any methodology. And he asked about standards. Are there any standards that are ever cited for determining dog bites? And these reviews and these studies that she went through, and she cited numerous reviews that she talked about, numerous studies that she talked about, which studied characteristics of dog bite wounds, right? So he was saying, in any of those, are there any like standards that like you use? Sometimes you can apply standards, right? Sometimes, like when it comes to, let's say, a broken bone, how do you diagnose a broken bone? Well, you take an x-ray. Then after you see the x-ray, you see if there's a broken bone, you see if there's a fracture, and then you're able to determine, that's a standard, right? So that's the standard of care. So he's asking, okay, so are there any standards when it comes to dog bite wounds? And it doesn't always necessarily work that way. I mean, you can have a methodology in determining whether things are consistent and whether they have the pattern of something without there being, yes, every dog bite is going to have A, B, and C. And this is the method and how you're supposed to diagnose them, send them to an x-ray, send them to a CAT scan, or whatever, when you find in other situations, other injuries are not necessarily always true when you have a different injury, and it doesn't mean that there's no methodology in how to determine it. So he was kind of mixing and matching this term of standard with methodology, and he was kind of saying, well, there's no standard, then there's no methodology, and this is kind of what he kept repeating. And then you're going to see in his argument, he also does this, that there's no methodology, keeps repeating that idea. And so therefore, just to really tighten it up and button it up, that is what Robert Alessi did. He said, okay, let's talk about how you determine whether something is a dog wound, whether it's a dog bite wound. And he said that patterns, the idea of finding patterns and using patterns in your diagnosis, where does that come from? And she said, oh, this is like textbooks. This is like what you learn in medical school. It's on all the textbooks. You have to find patterns. That's what it is. That's a lot of methodology for a lot of different areas, like discovering cancer. And a lot of things have to do in medicine with patterns. That's just the nature of a lot of injuries and treatment and diagnosis. You have to discover. So therefore, it's well grounded in medicine. It's in all the textbooks about this idea of pattern. And then what they do is they go through the studies. So he starts going through each one of the studies that she relied on and says, okay, let's go through that study. And that study showed they went through different ways that they're able to determine these patterns and to be able to relate it to a dog attack. And they go through the study step by step, showing that, okay, these are the methods that you employ when you're trying to determine and diagnose this specific injury as a dog bite. Okay, so that was a good job of him to rehabilitate her, to show that, no, these studies actually do show you that. And so therefore, he's trying to show not only does she have the knowledge and experience of being able to diagnose dog bites, but also she did rely on these textbooks and these research articles and these peer-reviewed articles to be able to come to her conclusion, which again will satisfy the Daubert the Daubert standard. And these articles also are cited oftentimes by other studies and other books. So these are not just crazy studies that were done one-off and nobody's ever cited to these articles or these reviews ever again. They're cited continuously by medical literature. So that's another part. Okay, then he actually went through some of John Walsh's or Dr. Walsh's opinions about this case, and she showed why what his opinions were are actually not reliable. So eventually we got to the argument phase of this Daubert hearing, and that's when also you saw some really good lawyering. I'm telling you, this is really good lawyering. It's going to be very interesting, definitely if you're a lawyer or interested in law, to follow this trial, because you're really seeing some really good, solid lawyering. So we had these arguments. So Hank Brennan went first, very, very strong, and he cited some cases. One case had to do with a handwriting analysis. And essentially, this is why he was trying to get her to say that it's a soft science, because in that specific case, and I missed the exact quote from that case, where that case is or what's the name of that case, but he said that there's this handwriting analysis that was they were trying to use this expertise, this expert, to analyze handwriting, and the courts threw that out because they said that doesn't satisfy the Daubert standard because it's considered a soft science. So that's why he was trying to get her to say that this is a soft science. So now he can make the argument that just like in this other case, when there's handwriting analysis involved, where the court found that it was a soft science, so too this is also considered a soft science. Dog bites and dog bite wounds, and determining whether they're actually dog bites, it's also a soft science, and therefore we have to strike Dr. Russell. And then he kept arguing again about this pattern recognition analysis. There's no methodology to it, and how she couldn't identify each one individually as relating to a dog, only with everything together. So he argued that. He also argued that past experiences is not good enough. Just because you have past experiences with dog bites doesn't automatically make you an expert to satisfy the Daubert standard. And he cited a case that has to do with a paint spill. Yes, paint spill. There's some sort of paint spill, and there was someone who's involved, I guess. And again, I didn't look up the case. I didn't hear the case, but some sort of case where there was a paint spill and there's going to be some sort of expert to testify that, from his experiences, that was a certain type of paint spill or something. So he argued that in that case, it says specifically that past experience is not enough. So he also argued that she flip-flopped between teeth and claw, what actually caused this, and she's not reliable. She can't be given the right to speak to a jury. She didn't go to Chloe, right? She didn't go to the actual see the dog or see the molds. And then Robert Lassie argued in response, and he said some very interesting points. He said, number one is that Judge Canoni said that the only way to prove causation is through a doctor. That's the only way to prove causation. We provided a doctor. The prosecution does not have any doctor testifying about how these injuries, or what the cause of these injuries are. There's no medical doctor who said that these injuries are caused or were caused by a car accident. No one said that. The closest that you can get to that is Trooper Paul. He's not a doctor. Okay. And Your Honor said, and this is what he was saying, Your Honor said that the only person who is competent and reliable to opine about causation is a medical doctor. And this is what you said is Massachusetts law. Well, the only people that did that was us. They didn't even have any doctor saying that. They didn't submit any sort of affidavit. So this whole hearing, really, he's arguing, is not proper, because if they want to challenge our expert, they need an expert. They need a doctor to say that these injuries are not from a dog, and these injuries are actually from a motor vehicle. So that's number one argument that he made. Then he talked about the methodology, and he said a bunch of times how Brennan is arguing and saying that there's no methodology, and he actually counted. He's like, he said it no less, I think he said 8 times, that there's no methodology. There's actually very clearly methodology. This pattern recognition analysis is methodology. That's exactly what we pointed to. That's exactly what we're proving to you. And then he argued that there is a number of cases. There's some federal cases which have specifically to do with dog bites. And although it's not a state case in Massachusetts, but there are some federal cases which show that this type of experience and everything that Dr. Russell has testified to in this case is exactly similar to what the doctor in those federal cases testified to and was allowed, meaning that doctor was not barred. They met the Daubert standard. So therefore, you should allow Dr. Russell to be able to testify, just like in those federal cases. And then he went on to Massachusetts cases. And in Massachusetts cases, he cited 2 cases which have to do with burn pattern analysis. So very similar to how an expert can actually determine, where the fire started by using burn pattern analysis. I'm assuming that's what it had to do with. Again, I didn't pull up those cases, but that's what it seems like it have to do with, how to determine either the cause of the burn or where it started from burn pattern analysis. So the same way that works, so too it should be able to work for this dog bite, which is also using the same exact thing, pattern recognition analysis. So it's recognized in the medical field. The case law recognizes this type of expertise as an expertise, and they should be able to testify to the jury. Now, the final thing that he made was the fact that Brennan did not object when he asked a question that do you hold these opinions within a reasonable degree of medical certainty? And he made a point that, during the trial, Lally objected every time they asked Dr. Marie Russell, do you hold these opinions within a medical degree of certainty? And that's why they did the Daubert hearing. And he said, so therefore, Adam Lally, when he was the prosecutor in this case, okay, he was preserving that objection. But since we asked this question a number of times during this hearing, and they failed to object, meaning Brennan failed to object anytime when I asked her, do you hold these opinions within a medical degree, within a reasonable degree of medical certainty, and he never objected, then he has essentially forfeited the argument. Now, I will tell you right now, it's a cute argument. That argument's going nowhere. Okay, so, but it was still cute to hear, and you always like to hear some argument from left field. So, but that was his argument. Again, his main arguments were that it's all rooted very solidly in the research, and the methodology was sound. It wasn't just her making things up. She has a lot of experience, a lot of training in this. There are certain cases that would say that training itself in a specific area like this is enough. That's what he cited these federal cases for standing for. And even if you want to say that that's not enough, still she had enough of these research articles, of these articles. And by the way, some of these articles are, remember that book that Brennan handed Dr. Marie Russell, some of these articles are actually cited in that book. So in that book where he was saying, oh, you should trust this book, some of those articles are actually cited that Dr. Marie Russell was relying on are cited in that exact book. So that essentially was the quick recap of what happened today. Obviously, Judge Cannoni did take it under advisement like she normally does on these issues. She's going to issue an opinion. And I got to tell you, I would be surprised if she does not allow Dr. Marie Russell to testify. Again, I mean, she may limit the scope of what she's allowed to testify to, but also one other thing before we sign off, and even though I know I tried to keep this under 30 minutes, but I got a little bit over time. One of the things that I was saying from the beginning, when they were talking about doing a Daubert hearing, is that the defense has to make the argument that not only should she be allowed to testify that these injuries are consistent with the dog attack, but they also have to argue that now we're having this Daubert hearing, so now it's clear that she can also testify because of her vast experience in treating and diagnosing car accident victims, that she should be able to testify that they are inconsistent, that these injuries are inconsistent with a automobile strike or motor vehicle strike. So that is actually what I did see the Robert Alassi arguing. That was one of the last arguments that he made, was that we believe that not only should Dr. Marie Russell be able to testify that these injuries are consistent with a dog, but also that they are inconsistent with being hit by a motor vehicle. So again, we'll see what Judge Cannoni does in this issue. I think she's going to have to allow Dr. Russell to testify. If she doesn't, it's going to be a major, major appealable issue for Karen Reed. But again, the trial is going to be completely different because, if they don't have Dr. Russell, so then, they're not going to have a doctor really. I mean, they'll still have the medical examiner, which is going to help. And maybe Hank Brennan's going to challenge him as well, try to throw him out. And we know that Hank Brennan actually just filed a letter with the court saying, a notice letter letting everybody know that he's about to file a motion to exclude the ARCA experts. So he's not stopping. He is trying to exclude all of the experts in Karen Reed's case from being able to testify that this was not a motor vehicle strike. And again, like I told you, the ARCA experts are crucial to Karen Reed's case. And now he's going to try to throw them out. So there's a lot more going on in this case and a lot more to follow. So the next thing that I have here is January 31st is going to be an oral argument about Rich Green. Now, remember, there was another motion that was filed about Rich Green, and that was whether his opinions are going to be allowed in, and he's going to most likely have a Daubert hearing. So that Daubert hearing is going to happen on February 6th, February 7th, and that is also when the ARCA motion is going to be argued by Hank Brennan about whether the ARCA experts are going to be excluded as well. So all of this stuff, we're just going to still wait on the motion to be filed. I know there was just a notice filed. It was a 1.5 pager, nothing exciting, just really Hank Brennan letting everybody know that he's going to file this motion to exclude the ARCA experts. So once that motion comes through, definitely we are going to get our hands on it and analyze it for you and see whether there's any sort of merit in that motion. So, but this is it. I mean, Hank Brennan is really rolling up his sleeves and he's really trying to win this case. And he knows that if he doesn't have to deal with ARCA experts, if he doesn't have to deal with Dr. Marie Russell, then he can more likely get a conviction out of this case. So that's going to be it for now. Thank you all for joining us. If you haven't yet, please subscribe, like, and we will see you next time.